Thanks for the nice words. It's an honor for me to be here and to be able to share my experience with you. And I hope the translation service is functioning fine. I see nobody looking weird, so that's working. I'm gonna tell you this afternoon a bit of origin verification and the way that works within the European Union. I know that there have been already a lot of seminars mainly focusing on origin criteria and determining the preferential status of a product. So we're going to focus on origin verification, so the more practical and pragmatic side of the agreement. I'm going to do this based on two topics, being documents used to claim preferential treatment in the EU. How are these verified, and what can you expect from that angle? And preferential origin documents issued in the EU, so documents that you might use if you import products with preferential treatment from the EU into Korea. So these two topics will be subject of the presentation this afternoon. On the picture you will recognize Mr. Kim signing the agreement, the victorious moment, and well, I'm glad and honored that he was willing to do the opening of this session today. So as said, two topics. First one is documents that are issued in Korea and that are used in the EU to claim preferential treatment. In which way are they subject to verification, and what may you experience from that? In order to do so, I will first provide you a bit of background, what will happen with these documents in practice. So where would these documents go as soon as you handed them over to your customer? Basis, of course, is that the products qualify for preferential treatment. Proof that they do is to be provided in the form of either normally a certificate of origin or a origin statement on commercial documents. Based on the Korea EU FTA, it's purely the simplified way, so only with statements on commercial documents. A company that may issue these statements is an approved exporter and is verified, authorized by the Korean customs authorities. So based on that authorization and under the control regime of Korean customs, a company may issue these certificates, so they have status. That means that that document is used to claim preferential treatment. Based on that one, the importer may file for lower duties upon importation in the EU. What happens with these documents? Normally, if you file a paper declaration, you need to attach them to the import declaration, so physically hand them in to customs. And then, well, customs can do with it whatever they want. However, current practice is electronic filing, e-filing. E-filing is the standard. In the modernized customs code, that will be fully implemented in the next few years somewhere. E-filing is the standard, so there won't be any paper filing possible within a few years' time. Furthermore, huge importers, big importers, use simplified procedures to clear their goods. So they don't file an ordinary import declaration. In both cases, there's only an electronic message going to customs, so there is no paperwork. So what happens in practice with the origin statement that you produced? It goes on file with the importer. It never physically reaches customs. So customs will only physically see these origin statements in case they would do a verification, a check of an individual declaration, and they would ask the importer to provide them with the file, or after a couple of years during a post-clearance audit, so a retroactive audit where they would come to verify the correctness of all declarations filed in a couple of years. That are the only moments where European customs will actually see the origin statement. So in practice, 90% of all shipments, of all origin statements, will never physically end up in the hands of customs. That as a background. If a document ends up on the desk of customs, it could be based on the fact that they want to really see that origin statement, but it could also be that they simply want to verify the customs value and they want to see the invoice, and the invoice carries the statement. Customs internally have the agreement that they have to check randomly a certain percentage of documents, and that randomly checking basically is a check by customs internally. That doesn't mean that certificates or statements are to be sent back to the country of issuance. Mainly what customs does is take a look at it, and in certain cases they have falsification experts that will take a look at it, whether it's an authentic document. They will look at it from a common sense principle. In certain cases you see very strange things. I've seen situations where products were brought in with a certificate of origin that mentioned a country where there was absolutely no industry for that type of product. Well, then customs becomes suspicious. I've seen shipments coming in with a certificate of origin mentioning Honduras. For the people that don't know, Honduras is somewhere in the Latin American area, with a bill of lading where it showed that the container was coming from Hong Kong. Well, Hong Kong and Latin America are two different ends of the world. There are situations where customs say, well, hey, that's strange, something's not correct here. Another method that's used in that respect, and that might be called common sense, is the numbering of containers for sea freight. Everyone will know that these containers have a certain number, and that number, based on that number, you can identify in which loop that container normally operates. A container is standardly on a loop between, for example, Northern Europe and Latin America, Northern Europe and Asia Pacific. It only operates within that circle. As soon as a container comes in with a number that belongs to another loop than the origin documents, then that's a trigger for customs to say, well, let's see what's going on there, because that's an inconsistency that that we don't trust. So most likely that's a document that will be in for further verification. Furthermore, the EU publishes notices in the official journey. As soon as they official journal, as soon as they have knowledge of certain issues in countries, could be fraud, could be misinterpretation. As soon as the EU authorities have knowledge of issues with the origin in a certain country, they will publish that, and that will also trigger additional audits on certain products. If, for example, the story would go around that within a certain industry in Korea the origin rules are misinterpreted, then that could trigger a bell in Europe, as a result of which publication is issued that is, well, be aware that products from that industry, from that country, there might be issues with the preferential status, that the origin is not correct. Well, you can bet on it that these shipments then will be subject to further verification. So that's what customs will do initially themselves. When needed, they will send back the origin statement to the country of issuance, but only when needed, so when they have serious doubt that it's not correct. In other cases, where they have reasonable doubt based on the certificate itself, so without the random check, the certificate is always sent back to the country of issuance under the mutual assistance agreement. The importer will be informed, need to be informed by customs in the country of importation that the certificate will be sent back for verification to the country of issuance. So the importer will be able to inform the exporter of the fact that a check will be performed. But it will always be from customs in Europe to customs in Korea, and customs in Korea will then either verify with you as an exporter or immediately reply themselves to European customs. It will always be based on the EU-Korea FTA customs to customs. It's not common that European customs authorities will directly liaise with a company asking for documents, asking for proof. It will always be via their own local customs authorities. If a document is sent out, so sent back to Korea in this case, and the authorities don't reply within 10 months, then based on the legislation, the certificate automatically is invalidated. And what that means, we will see on the next slides. Another option, apart from the random check, and apart from the certificates where there's direct reasonable doubt, is a OLAF mission. And that's a special category. OLAF is the European Anti-Fraud Office, and they are sent on a mission by the European Commission as soon as they have clear information that something is wrong. At least that's their idea. And mind you, if I say they are on a mission, it's like a kind of James Bond movie. If they are on a mission, they're on a mission. And they're only out there to gather facts that substantiate what they have in mind. If they are involved in an investigation, then it's time to seek professional assistance, because they are only using the information that's beneficial to their own investigation. But that rarely happens. Normally, it's all dealt with either nationally by the authorities themselves, where they say, well, does this look correct? Yes, it looks correct. Well, then there's no need to send it out and bother the Korean authorities with it. If there is doubt, usually the Korean authorities will be asked to confirm that indeed that certificate is, or that statement is correct, and is valid. So normally it's authorities between authorities, whereby the Korean authorities might get back to you to ask questions. But in a number of cases, even that won't happen. Could be that they simply ask, is this certificate or is this statement indeed issued by this company? And most likely, based on their own intelligence, they can simply confirm that. So that's when and how certificates or origin statements issued to the European importers are verified. This topic had been subject to review by the European Court of Auditors, and you shouldn't try to read the complete text out there. It's just as a kind of picture to give you an idea. European Court of Auditors is doing checks randomly on various issues. And one of the last reports on customs, they also checked the usage or the application of preferential origin documents upon importation in the EU. And I've mentioned a summary of the text on this slide, and I won't read out the complete text. That's only boring. Summary of the text is that declarations where a preferential duty rate was claimed were subject to investigation, and a high frequency of errors was found in 6 out of 9 member states. So 2/3 of the member states had a high frequency of errors in the area of preferential treatment. And the issues, they mention a few lines furthermore, that the importer did not possess the necessary documents. So we have a system whereby the document is not to be handed in to customs, but you have to put it on file yourself as an importer. And still, what the European Court of Auditors found, that doesn't happen. That doesn't mean anything about correctness of a certificate. It just means that the European importers have a bit difficulty in file keeping and registering the documents. Most likely, they're all products that are eligible for preferential treatment. It's just that they messed up with their archive and they couldn't produce the origin statement when needed or when asked for. What it does mean, however, because these things, the European Court of Auditors is seen as a real authority in Europe. As a short background, customs duties in Europe are what they call own resources of the EU. So every euro that's collected on duties is by the member states is to be paid off to Brussels, as it's called in Europe. As soon as we talk over on the European Union, everybody names it Brussels. And so every euro is to be paid off to Brussels, and 25% may be kept locally to cover cost of the customs organization. So the European Court of Auditors comes out to verify whether the amount paid off by the member states to the European Union is sufficient. So in this case, if they find out that preferential treatment was allowed where it couldn't be proven, the member state receives an additional claim from the European Union, irrespective of the fact whether that member state can collect the money from the importer. It's the EU versus the member state where there's an issue. So the member states are rather afraid of the European Court of Auditors because that's likely to cost them money. So if the European Court of Auditors detects an issue like this, it won't be a surprise if I mention that this topic is high on the agenda of customs these days, because they want to avoid this from happening again, because this is simply costing them a lot of money. So there will be an extended focus on, mainly the file keeping and the verification of preferential origin documents and statements used upon import in the EU. A few words on the legislative side. What happens if at a certain moment a document is subject to verification and it would be proven to be not correct? Would that be a huge issue? Well, from a legal perspective, the document first needs to be invalidated. Without invalidation, they can't issue a retroactive assessment. To invalidate a certificate, basically input from the country of issuance is required. So in practice, the Korean customs authorities need to confirm to the European customs authorities that indeed that origin statement was not correct. Only then it can be invalidated. Or what we saw on the previous slides, if a request for mutual assistance is sent out and there's no reply from the Korean authorities within 10 months, then automatically the certificate is invalidated. Unless it's clearly a false certificate or a false statement. If that can be proven, then it's considered to be invalid anyhow. The fact that customs authorities have doubt to the correctness of a origin statement is no reason to refuse preferential treatment. That's stated in the customs code. So people that are threatening all kind of things about not granting preferential treatment if something is not fully in line or to the wishes of, for example, the Greek or the Italian customs authorities. No, it first needs to be invalidated. Of course, a certificate first needs to be accepted. If a certificate isn't available, like we saw with the audit of the European Court of Auditors, if there is no certificate, there's nothing to invalidate. And then it's quite simple. That's a duty assessment if you can't prove the origin. If there is a certificate and if it is initially accepted by customs, and if you have an electronic filing or simplified procedure, it is automatically accepted because customs don't see it. You have to keep it on file yourself. So as soon as your import declaration is accepted, also the origin document is accepted, then it first needs to be invalidated. Doubt by the customs authorities is no reason to refuse preferential treatment. If a certificate is invalidated, then of course there's no preferential treatment and duties will be due. However, there we have to consider the statute of limitation. Customs can't simply file retroactive assessments as they like. There is a 3-year statute of limitation in the Community Customs Code. So 3 years after finalization of the import declaration, within 3 years, customs can file a retroactive assessment. No day more. That goes from day to day. So not 3 calendar years, 3 years from day to day after filing of the declaration. However, in case of an act that's liable to give rise to criminal court proceedings, practically, you could say in case of fraud, the time period can be extended. And that's based on national legislation that differs per member state. In the Netherlands, for example, that means that in that case, the statute of limitation goes to 5 years. If you take France, for example, there they have a mechanism where they say, well, if it are consecutive transactions, we can go back for as long as the transactions took place. So if you are doing the same type of business for 20 years, they can go back 20 years. That's a huge difference between member states. That's also the reason why in the modernized customs code, the authorities have said, well, we need to draw one line that is equal for everyone. And under the modernized customs code, to become effective in the next years, there's a 10-year period. So within 10 years, the authorities may file a retroactive assessment. And that's where a strange thing happens. Because in the FTA, you all will have seen, there's only a record-keeping obligation of 5 years. So under the FTA, after 5 years, you can put the shredder on and get rid of all your documents, clean up the archive. But you can be held liable for a period of 10 years. And a lot of companies, people will say, well, that's not a problem to me because I'm not into acts that could give rise to criminal prosecution, so I'm not acting fraudulently. I fully accept that, fully agree to that. However, it's not what you think, it's what the authorities think. So if they have the idea that you are involved in an act that could give rise to criminal prosecution, you will need the documents to protect yourselves. You need to prove that indeed you acted properly, that you indeed didn't do something that could give rise to criminal prosecution. So as part of your defense, you will need the documents. So do yourself a favor and do not adhere to the 5-year period mentioned in the FTA, but try to stick to the 10 years that will be applicable in the EU in a couple of years. So make sure that your file-keeping structure is up to speed with the need of the documents in practice rather than with the legislative side mentioned in the FTA. If a claim is filed, so if it is concluded that indeed a certificate is invalid and duties are to be paid, question of course is who will then need to pay them? And this is where the lucky story is for you. The debtor is always the importer or the declarant. That's the one filing a declaration on behalf of the importer. The exporter is out of scope. So it's always the importing party that has to pay duties. And then depending on the way an import declaration is filed, that could either be the importer itself, the declarant itself, or the combination, depending on the type of what's called representation. If it's direct representation, then it's the importer that's fully liable. If it's indirect, it's a joint liability. If there's no representation, the declarant, so in practice the customs broker, will be fully liable. But it's always an EU party. So the one that actually prepared the wrong document is, for customs, out of scope. Sounds lovely. I think we all know and realize that if your client has an issue based on a document that you wrongly issued, that you at the end of the day will have an issue, a huge issue. Apart from the fact that duties are due, it's of course quite embarrassing that your customer is in trouble based on the fact that you made an error. So legally, lovely. In practice, I think you're all in the same boat with your customer, and there's an issue anyhow. And I think the best way to do that is to solve it together and make sure that the relationship isn't completely ruined by an administrative error. But legally, European customs won't charge the duties to you. They will only charge duties to the importer or the declarant. Within the European Customs Code, there is a kind of escape clause, or a waiver if you like. In Article 220 of the Community Customs Code, there was a subheading introduced under 2b in the year 2000 as a result of huge claims based on false or incorrect certificates of origin. As you might know, also based on the origin criteria mentioned in the EU-Korean FTA, for certain products the origin criteria are difficult to interpret. Textile sector is extremely hard to interpret. If you're involved in that sector, I would say, well, you actually would always need an advisor that knows exactly how to interpret these protocols, because that's complicated. It showed that in certain countries, and I think Bangladesh is the best example of that one, also the authorities had real difficulty in interpreting the origin protocols. And they issued documents based on information of the exporter. They provided correct information, showed their complete file, and the Bangladeshi authorities, based on that information, concluded that the products did qualify for preferential treatment, which they actually didn't. But they misinterpreted the protocol. Then, of course, you run into the question, who's to blame? The importer receives a claim for an error made by the Bangladeshi authorities, where the exporter provided all correct information and said, well, I think this qualifies. And the authorities said, well, yeah, we agree. So they issued the certificate. It wasn't a false certificate. It was simply wrongly issued, but issued by the correct authorities. And there, the European legislator said, well, that's a bit of a strange situation. If you, as an importer, acted properly, and the authorities made an error, then we need an escape clause to prevent you from being charged for additional duties. So if there's an error on the part of the customs authorities, which you as an importer could not reasonably have been detected, and you acted in good faith and complied with all provisions, blah, 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 then there is an option to receive a waiver from duties being payable. It sounds great, but this note only applies to certificates. And the EU-Korea FTA only includes origin statements based by approved exporters. So there are no certificates. So this clause doesn't apply to shipments under the EU-Korea FTA, unfortunately. So there's no escape for the importer. That's on the verifications that are performed within Europe on documents issued in Korea. So in summary, if there is verification, normally the importer is informed of it. Verifications are done between customs authorities, and the only people that normally would contact you as an exporter with questions are the Korean customs authorities. It's not common that European customs authorities come over to Korea to visit you and to scrutinize your export file. That is not common. It could be at a certain moment that the Korean authorities would say, well, we don't know, come over and assist us, or the other way around, but it's not standard procedure, and they will, if there would be European officers, then they would dare to accompany the local officers. But you will only have to deal with the Korean authorities where the EU-Korea FTA is concerned. Keep that in mind when listening to them in a few minutes. The other topic is certificates that will be issued within the EU, so the documents that you will receive for claiming preferential treatment here in Korea. In that respect, it is important to know that within Europe, there's a difference in who issues these documents. If we take the ordinary certificates, there are countries where the Chamber of Commerce issues them, and there are countries where customs issues them. If the Chamber of Commerce issues them, then basically the Chamber of Commerce determines the origin, and customs then links that document to the shipment of goods. But the knowledge regarding the origin is in those countries mainly with the Chamber of Commerce. So if you have a document from a country where the origin certificates are normally issued by the Chamber of Commerce, for sure the knowledge within customs of the origin criteria is limited. I'm from the Netherlands, where, as mentioned on the list, the Chamber of Commerce is the authority to determine the origin. And I can assure you that the knowledge within Dutch customs regarding preferential origin is limited. I think on a total of some 3,000 customs officers, there are 2 that have in-depth knowledge of origin, and all the others rely on those 2 people and on the knowledge of the Chamber of Commerce. However, approved exporter status is something that's to be applied for and issued by customs. So in a number of countries, the authorization is issued by the authorities with the least knowledge. That sounds strange, it's practice. So what happens, or what happened, I have to say, is that many companies received approval in the past without a proper control environment being in place. And what you saw there is that issuance of origin documents or origin statements was mainly sales driven, meaning that if the client insisted on having an origin statement on the invoice, then there was an origin statement on the invoice. Of course, everyone in here will know or will acknowledge that the real reasoning should be, if the goods qualify, there will be an origin statement on the invoice. If the goods don't qualify, there won't be an origin statement on the invoice. But what you often see is that sales keeps pushing and pushing to have that statement on the document. They may be pushing, but then we need to be pushing in the direction of purchasing and sourcing to see whether we can manufacture products that do qualify, rather than for a product that doesn't qualify, try to get the statement on the invoice. That's what happens in practice. Nowadays, there's much more focus on the approved exporter, also based on the observations from the European Court of Auditors. Origin is in scope, so also the approved exporter status is in scope. And what you see nowadays also as part of the authorized economic operator certification process, that customs are much closer monitoring also the issuance of preferential origin documents. And of course, companies run the risk, if they don't treat this properly, that they ultimately might lose their AEO status based on wrongly issued preferential origin documents. So there's much more interest these days in doing this properly. However, if Korean authorities have doubt as to the correctness of a document, or they also want to perform a certain random check, they can also send back documents and request the European customs authorities under the mutual assistance agreement to do checks. It happens in practice, and what often happens then is that issues show to be in place. The main thing is record keeping. A lot of companies don't know for which shipments they have and for which shipments they have not issued preferential origin documents. The proof of origin proves to be quite an issue. Suppliers' declarations that are not in place, suppliers' declarations that are no longer valid, declarations from last year, declarations for slightly different products. And there are also companies that still mix up origin with preferential origin. So economic origin, if you like, or made in origin versus preferential origin remains complicated. And what we see in practice is that a lot of people have difference or difficulty with the interpretation of the origin protocols. Not only companies, but also customs authorities in some cases have difficulty in reading the protocols, especially the X headings. I think most of you will have seen them. That's always a tricky issue, where the X means that the rule mentioned behind the X only applies to these specific products, and for the other products of that heading, the standard rule applies. In most cases, that's interpreted the other way around, and that causes a lot of practical issues from day to day. So if a company wants to apply best practice, then in my view, if you are an approved exporter, you need to have a proper origin management system. It doesn't mean system in a way like a computer system, but at least a standard process that's documented, where internal controls are in there, where it's clear where your records are. And the basic principle should be no preferential origin unless it's proven to be preferential. Where some companies from a pragmatic choose for a pragmatic approach and say, well, it's preferential origin unless we don't have the proof. Well, I prefer the other way around to avoid huge issues, to say, well, there's no origin unless we have the proper documents on file. And when you claim preferential treatment, whether you're in Europe, whether you're in Korea, if you're claiming preferential treatment based on a document issued by someone else, make sure you know your business partners. Who are you dealing with? Is it likely? Does it make sense that the products qualify for preferential treatment? If you don't receive a statement of preferential origin, you may ask your business partner why. But if you force them to issue a statement, might very well be that you receive one, but an invalid one. And why they issued it? Yeah, because you asked for it. and you're in trouble if it's proven to be wrong. So if they don't issue one, you may ask for it. So, well, why don't you issue such a certificate? Well, could be that they're not an approved exporter, that they still need to apply for that authorization. Well, could be a lengthy process. I think in general, if you take Europe, that it's something that could take easily up to 6 months before that is available. Could be the reason. Well, then they might issue one retroactively later on. But if you force people to issue one, then it's likely to be a wrong one. So make sure that you know who you're doing business with, and that the certificate is likely to be correct. Scrutinize documents and make sure that you have proper record keeping, that you don't end up like the companies that were part of the test of the European Court of Auditors that claimed preferential treatment, and at the moment it was needed, they couldn't produce the documents. So keep that in mind when dealing with preferential issues, and you can reach what I would call best practice under the EU-Korea FTA. That's what I had in mind to tell you on origin verification. Initially, I would like to thank you for your attention so far, and if there are any questions at this moment, I'm happy to take them, and I'm going to run to the table to listen what they are via the translator.